Happy June 29th, everybody. Or as some would say, National Bacon Burn-In Day, celebrating the delicious caramelized twice smoked pork belly tip, a Kansas City barbecue specialty. So, Kansas, if you ever want to visit a real barbecue, make sure you bring your bacon, but come down south. They can go ahead and show you a thing or two about barbecues. Today, we're going to be going over some of the Supreme Court cases that have happened over the past week, all dealing with the federal administration. Some will weigh in on the administration side, some will not. These are all intended to make sure that they hold within the integrity of the Constitution. I understand that some judges are going to absolutely side more party wise, even though they are not supposed to. However, I still believe that the integrity of the Supreme Court and federal judges is in a majority, that their focus is Constitution first, not party first. Some judges will think more liberally, some judges will think more conservatively. That does not mean that they're not thinking about the Constitution. It just means that they are interpreting the laws differently. How these cases are going to be run are they are going to go off of case, ruling, the reason why the ruling is that way, and the impact that this can have on the country. I'm also going to include my take after each and every single one of these cases. These are my personal opinions. These do not represent the entire Libertarian Party. I am a pragmatic Libertarian. I am willing to forego ideologies in interest of the betterment of the country. So the first case would be Mullen v. Alatro Lato. I hope I pronounced that right. I haven't actually heard somebody actually say it. However, on June 25th, the U.S. Supreme Court ruled in a 6-3 ruling that federal officials may deny asylum seekers access to U.S. ports of entry by using the metering policy, holding that individuals stopped at the Mexican side of the border have not yet arrived in the United States under federal asylum law. The majority concluded that asylum protections requiring inspection apply only after an individual physically enters the United States, not before. The dissent argued that the ruling allows the government to avoid its statutory duty to process asylum claims simply by preventing entry. This decision allows the federal government to reinstate border metering, significantly affecting the asylum claims and how they may be processed at ports of entry, and clarifying the executive branch's authority over border access. The second case, Mullen versus Doe. On June 25th, the Supreme Court ruled in a 6-3 ruling that the temporary protected status largely bars judicial review. This is because Congress gave broad power to the executive branch for determining TPS designations, making it easier for them to be able to terminate TPS. This also means that in the future, there will be less cases on temporary protected status in judicial review. This means that hundreds of thousands of Haitians and Syrians are facing deportation because of an expiring TPS status. Now, my take on this would be to actually look at the individuals and are they providing a positive to the United States or not? Now, I understand that there's housing crises. However, as we can see from the ICE deportations, just because a whole bunch of people leave does not mean that it is going to make the economy better. All of the ICE deportations did not improve our housing issue. It did not improve our economy. In fact, as a reminder, undocumented immigrants provide over $100 billion in tax revenue throughout the entire United States in taxes. That's money that we wouldn't have beforehand. And they bring in thousands of dollars in economic prosperity throughout the country. These are things that we will lose even with removing temporary protected status. So, I think that each individual should be able to state their case to be able to maintain temporary protected status. If they have been doing what they can to be a part of the United States and contributing to our economy and contributing to the workforce and paying taxes, then I see no reasons why those individuals should have their temporary protected status expired. In fact, possibly a chance for residency to extend to them. However, if they only want to survive on temporary protected status, then send them home. However, if they are here on TPS and they are contributing to our economy and you give them the opportunity to become a permanent resident, let them continue to contribute to the United States. This is not meant to sound like a backdoor way to immigrate. You have to be providing a net positive to the country if you want to stay. Like, that is common sense. That's literally common sense right there. However, the party that claims to be of common sense will likely be the ones to deport them anyways, regardless of whether they provide a net positive to the United States. On the third case, Trump versus Slaughter, on June 29th, the Supreme Court ruled 6-3 that the president has constitutional authority to remove Federal Trade Commission commissioners, overturning much of the court's 1935 precedent in Humphrey's Executor. The majority held that the FTC's commissioners exercise executive power and therefore remain accountable to the president under Article 2. However, the dissent warned that the ruling substantially weakens the independence of federal regulatory agencies. This decision expands presidential authority over independent agencies and could affect the leadership and independence of multiple federal commissions beyond the FTC. My take on this is just because the president has the authority doesn't mean that they should use that authority. History has shown that governments can become unstable when leaders prioritize loyalty over competence, as seen in countries like Russia and Turkey. Independent agencies exist to provide balance and prevent excessive concentration of power. In today's political climate, where people often stay within echo chambers, it is more important than ever to encourage open dialogue and critical thinking. Blind support for any political party can lead to poor decision making. People should be willing to question policies, even when they come from leaders that they generally support. Additionally, I would like to add on to this that Jubilee has created a new episode called The Split. This is an opportunity for people to be able to talk from both sides. Where I talked about the echo chambers, this is something that is supposed to fight back on those echo chambers and to encourage actual open dialogue. It's something that I would encourage everybody to do. By staying in just your lane and only wanting to hear things that benefit you and to argue completely against the opposition does not do the country any benefit. So I would encourage you to check out The Split on Jubilee and see how you like it. And also talk to your friends. Look, you're not going to always have the same opinion. I am getting really off topic right now, but this is important to bring up that you're not going to agree with somebody 100%. If you agree with somebody 100%, you're either lying to them or they're lying to you. And the fourth and final case that had a ruling, Watson versus RNC. The Supreme Court actually ruled in a 5-4 split on this one that states may count mail-in ballots received after Election Day as long as they were timely postmarked, rejecting a challenge to Mississippi law. The majority concluded that federal law establishes Election Day as the deadline for voting, but does not require every ballot be received on that day. The dissent argued that the ballots arriving after Election Day conflict with federal election statutes. This ruling preserves similar mail-in ballot deadlines in multiple states and provides additional guidance on how federal election law interacts with state ballot counting procedures. My take on this is that elections are crucial to our democracy. And yes, we are a republic, but a republic is a representative democracy. This means that every person's vote is critical, and that's why we have systems like absentee ballots for those who cannot vote in person for whatever reason. However, to improve efficiency and public trust, I would highly recommend and champion states to start counting in mail-in ballots early. There's no harm in counting ballots early. At least I personally see no harm. Maybe somebody else can bring up some idea where there's more harm in that. It doesn't mean that you actually have to report those numbers until election day, but it would be great if they are. And I do want to remind people that live on the East Coast, one of the reasons why it takes more time for the West Coast to report in their ballots is also because they are 4 hours behind. Additionally, are you aware that the city of Los Angeles has more people in it than 20 of our smallest states? So the fact that those small states get their ballots in so quick and it takes California a long time, well, that probably has to do with the fact that a single county is counting more ballots than 20 states combined. Like, that's not their fault. Obviously, people like Los Angeles County if they have that many people. That is not election fraud. That is the fact of life that more people want to be in that area. It is a land of opportunity. And yet, every single election that Republicans lose, they blame cheating. They say that there is cheating, despite the fact that even far right conservative think tank, the Heritage Foundation, has said that there has not been widespread fraud. But it does not change the fact that they changed that narrative. In 2016, it was a perfectly free and fair election. In 2020, there was obvious cheating. In 2024, free and fair election. They already see the signs that they're going to lose the House and possibly, but unlikely, the Senate. So they are already trying to push the narrative that there is going to be cheating. Because of this, I highly recommend that ballots that are absentee ballots are counted early as much as possible, so that way the numbers aren't such a large jump later on. Well, I definitely got excited in that last one, but I've got one more surprise case for you. This case will not be heard by the Supreme Court because the Supreme Court has rejected it, meaning that it stays within the lower courts. And that is that they will not hear Trump's appeal against E. Jean Carroll. For those of you who don't know, the president was held civilly liable for sexual assault of E. Jean Carroll. The reason why it was a civil suit, not a lawsuit, is because the statute of limitations had passed. This has nothing to do with the president. This has to do with my own moral standing. It is my personal opinion that if somebody physically assaults somebody else, there should be no statute of limitations. Because we can see cases where people are afraid to speak up for one reason or another. And they should not be penalized, and we should not allow people to walk the streets if they are guilty of harming someone else. Having said that, the reason why it was also sexual assault and not rape was because in the state of New York, at the time, it required penile insertion and it could not be the fingers for it to be considered rape. Since then, those laws have been changed, thankfully. However, that is one of the situations that saved him from being held civilly liable for rape. Now, there are some that are going to be on Trump's side. There are some that are going to be on E. Jean Carroll's side. I'm just going to say, before you take a side, read the actual court documents with an open mind. Because that case had a lot more surprises than even I expected. Anyways, those are the Supreme Court cases that we have seen over the past week that affect the administration. Those are my takes on every single one of them. I hope you enjoyed this. If you enjoyed it, please come back for more. Anyways, have a great day.